to Commonwealth versus Medeiros.
Oops. Good morning, Ms. Marmor.
Good morning, Your Honor. Stacey Gross-Marmor for Kevin Medeiros. Your Honor, I'd like to first start talking about the third issue that was presented in my brief, which would be the fact that Mr. Medeiros' conviction for aggravated rape cannot stand because it is a legally inconsistent verdict, premised basically upon the fact that his co-defendant was acquitted of all rape charges. Massachusetts.
In other words, the same issue that we were just discussing.
That is correct, Your Honor.
Was he acquitted of everything or just of the rape?
He was just acquitted of the aggravated rape as well as the rape with force. He was convicted of the assault and battery. I would suggest to the Court, though, that the assault and battery charge is not sufficient to sustain Mr. Medeiros' aggravated rape conviction.
And your theory of that, as I read your brief, is that it's because of the factual circumstances of this case, namely that the jury could have reached the conclusion that prior to any rape occurring, namely grabbing her, pulling her into the tent, was sufficient to convict the co-joint venturer of assault and battery. And so it might have had nothing to do with the rape. Am I correct?
I think my argument is more intricate than that. I think, number one, you can't rely on the assault and battery charge because the assault and battery charge for Mr. Watson was indeed based on separate and distinct facts. I think that's demonstrated by the jury instruction that was provided to the jury in this case, which set forth the facts that they needed to find to convict Mr. Watson of the assault and battery. I also think that it's demonstrated if you look at the defendant's motions for required findings of guilty at the close of the case. They had asked that both the assault and battery charge as well as the indecent assault and battery charges be dismissed against both defendants. And the judge decided that she would dismiss the indecent assault and battery charges because they were linked to the rape. But she also found that the assault and battery charges were separate and distinct. I think it's more involved than that. I think you also have to look at the aggravated rape statute, Massachusetts General Law, Chapter 265, Section 22.
Which you haven't included in your brief, am I right?
I included it in the reply brief in the addendum.
I'm just trying to look for it.
Could the jury have determined that a joint venture did exist but acquitted the defendant for some other reason?
I don't believe so. If you're looking at the actual convictions, they found that an assault and battery was committed by Watson, and they found that Mr. Medeiros committed the rapes as well as the assault and battery. But aggravated rape requires as an element that there be a joint venture. And I think the joint venture goes beyond that some joint venture existed. I think there needs to be a joint venture to commit rape.
Well, yes, because it says that the rape is committed by a joint enterprise, so that would support that view.
Right. And in this case, it's distinguishable from many of
I'm saying, what if the jury acquitted the co-defendant out of sympathy for him?
I would suggest that it's a legally inconsistent verdict. You can't reconcile the two verdicts. You can't reconcile the fact that they acquitted Watson of the rapes, yet found Mr. Medeiros guilty of a joint venture. The joint venture did not exist. They found in their acquittal, that verdict found that there was no joint venture. There could not possibly be a joint venture. There's no facts upon which the jury, listening to this entire trial, could find, if they acquit Watson, that a joint venture exists. This case is distinguishable from Clements. In Clements, there was a principal and a joint venture. They acquitted, I believe it was the principal was acquitted. One of the defendants was convicted of joint venture. But there were separate facts in Clements that the jury could rely upon in finding the joint venture guilty. There were two guns.
Well, in Clements, there was no joint venture was not an element of the offense, was it?
It wasn't, but it's also interesting.
But isn't that really the important part of this case?
In this case, it's vital. It is that it's an element of the offense.
There's also the case that in Clements there was principal and joint venture liability. Clements was written before Zanetti, but there was principal liability, correct?
Right, but I think that the analysis of the court in Clements is important because in Clements there are two guns, there were witnesses that said that they saw more than one person, and so it was possible for the jury to find that a joint venture existed even though the principal was acquitted. This case is different. Here, you basically have two men in a tent. If you acquit one of the men of rape, it's impossible to find that a joint venture existed.
Well, go ahead. Here he was charged with two rapes.
Correct.
And and I gather he was convicted of the aggravated rape because that's when Watson was there, and the other rape was after Watson had left. Was that what the jury was told?
I believe it was one rape, but there were separate elements to each rape. One was rape with force, and then the aggravated rape had the joint venture element. So, I mean, to be quite frank with you, Mr. Medeiros' rape with force conviction still stands. It's the aggravated rape conviction that needs to be.
Well, you still have to have force for rape, for aggravated rape. It's the child. The child
Yes,
was...
it was. I'm sorry, Your Honor, you're correct. It was rape with force of a child because the complainant in this case was 15 years old.
But it's one rape? I mean, is it coming at the same rape with two different statutes? Is that what you're saying?
Exactly, Your Honor.
So even if this one, so even if the aggravated rape is impermissible, that still leaves the rape of a child with force, right?
Absolutely, Your Honor.
Okay.
It does. But
So
at
the
the same
practical
time,
effect of this is?
the practical effect is that Mr. Medeiros has 3 convictions on his record. He has the assault and battery, the aggravated rape, and the rape with force of a child convictions on his record. The aggravated rape conviction should not stand. It was a legally impossible verdict. His sentence was affected by the aggravated rape conviction. The judge said during the sentencing hearing, this is a very serious offense. You've been convicted of aggravated rape. She took the fact that he was convicted of that offense into consideration. He received his sentence on the aggravated rape charge, and then she said, I'm going to put you on probation for both the assault and battery as well as the rape of a child with force.
This was my question, and I didn't ask it well. Are you suggesting, which I thought maybe in answer to Justice Gantz you were, that it is there was one rape? So I guess my question is, are these duplicative convictions?
They're not duplicitous because they have separate elements. You have the rape of a child with force, and then you have the aggravated rape, which would be the rape via joint venture.
Well, I mean, that would be lesser includative under that, if that's your analysis. I had thought the facts of the case were there was penetration with Watson there. Watson says, I don't want any part of this, I leave. And then they went on with more penetration afterwards. So you're saying that the jury was told that there was one rape, or the jury told that there were 2 separate rapes, one with Watson there and one without Watson?
The jury was told that there was one rape. They weren't told that there was a rape with Watson and then there was a rape without Watson. The jury was told that there was one rape.
You didn't have to prove that a child was the subject of the rape in the aggravated rape case.
Correct, Your Honor. You do not.
Or the Commonwealth didn't have to prove it.
Exactly, Your Honor. There are different elements to each offense.
Ordinarily, when there's an inconsistent verdict, what we do is we look at the evidence against the person that was convicted. And clearly the evidence here is sufficient. Just look at through the evidence presented against your client was surely sufficient for aggravated rape.
Except for the fact that the jury found that Watson did not participate in the rape. And so
I understand that. But if your client had been tried separately, it would be no problem at all.
I would agree with that. But here you have a jury that acquitted the only possible joint venture.
As Justice Cowan points out, there may be lots of reasons for that. Well, not really as culpable as the other person. Aggravated rape, pretty serious. I mean, aren't there all kinds of reasons we shouldn't get into the head of the jury on this?
I understand. And
it's not impossible as a matter of law.
Right. And the philosophy on that, we don't want to get into the head of the jury because we don't know why they decided it, and the defendant as well as the Commonwealth could benefit from their train of thought. But here, the defendant is the only one who is at a detriment. He's been convicted of aggravated rape. His co-defendant has been acquitted of all rape charges, and he's receiving an enhanced sentence, while the co-defendant was simply sentenced on assault and battery. And I would suggest that here, where the jury's verdict makes absolutely no sense, that you do need to overturn the aggravated rape conviction.
I guess that's the question that Judge Cordy is asking. How dependent is our finding that it makes no sense? Because what you're hearing from us is it does make some sense. There were differences in culpability, and the jury could have sensibly said, we don't, out of our inherent power, choose to convict him for a crime that he is guilty of because his role was sufficiently small, he wasn't the major player. We don't think we want to have this person have this on his record. It's sensible. It may be legally inconsistent, but is your argument to us that it's not sensible or that there's some other reason for it?
It's not sensible. It's inconsistent. You can't reconcile the 2 verdicts. They don't make sense when you put the 2 verdicts together. The 2 verdicts do not make sense.
I take it your answer is take away Trevani in that line of cases. You know, we could go back and say we don't like Cerveni, but in fact there's a long history of saying if you have conspiracy or joint venture or a whole bunch of other joint enterprises of the jury in the same trial. I mean,
Correct.
Cerveni, Chief Justice Hennessy lays it out. In another trial, there might have been an excluded piece of evidence. The Commonwealth, the prosecutor might have argued more forcefully. The defense might have argued more forcefully. We're not dealing with that. We're just talking about same jury, same evidence, same instructions, same everything.
You're right. I would suggest that Cerveni supports my position in this case.
Of course it does. What I'm saying is that we could go back and revisit Cerveni and say, no, we don't, we're just changing the law on that.
Yes, and I would suggest to the court that you should not revisit Cerveni in this case. This is a case where it makes no sense, and the person that's at detriment is Mr. Medeiros.
Well, I mean, Cerveni also says it may be that the acquittal was an injustice. So should we propagate another injustice by reversing the conviction that's based on sufficient evidence?
Right, and that train of thought is basically the defendant could have been harmed or the Commonwealth could have been harmed, but that's not the case in a joint venture situation. Here, you're protecting the acquitted defendant's verdict.
If these defendants had been tried separately, would you be arguing the same way?
I don't think the argument would exist if they were tried separately.
Isn't
it would be
your-
separate juries.
Wasn't Justice Spina at the beginning right in it? What makes this case like Cerveni or Cerveni is that in this case, as opposed to the case we just heard, for example, there is a statutory element of this offense, is that the rape was committed by a joint enterprise.
Correct.
So it's not just that he was tried as a joint venture, it's that you've got a statutory element of the offense, which is the equivalent, or one could argue, is the equivalent to the fact that in a conspiracy case, an element of that offense is that there is an agreement.
Correct.
So if you have one person who's acquitted, you can't have an agreement. And you're saying so that you have lost one of the elements of the conviction. And you're saying here, because of the statute, if you don't have the other person, the only other person who's possible as part of that joint venture, you're missing one of the elements of this statute.
Absolutely, that is correct.
So if this case had been tried to two juries simultaneously, one set of evidence, one set of witnesses, and there's a jury on the left-hand side of the courtroom for the defendant and a jury on the right-hand side of the courtroom for the co-defendant, one of them gets acquitted, you're saying that's okay?
I would say that is okay because you have different juries. Here you have one jury acquitting.
What difference does it make whether there's one or two juries?
Because you cannot reconcile the verdicts. You simply cannot reconcile having.
They liked the way the guy smiled. Completely irrational. That's why they let one of them off.
I understand, but as I've said before, here you have one jury. They've acquitted one gentleman. They've convicted the other gentleman. It's an element of the offense of aggravated rape that they find mutual intent to rape. The jury in the acquittal of the second defendant of Watson
but that's also
found that
true.
that did not exist.
That's also true with separate trials.
You have separate juries. They can find separate facts. There's a separate analysis involved. Here you have one group of people acquitting one defendant and the same group of people acquitting the other defendant. Convicting and acquitting. I'm sorry, I got a little mixed up. I think it's different. I think it's different than having two juries. You have one jury, and you cannot reconcile their decisions here. The decision makes absolutely no sense.
Well, I take it the evidence in this case would have supported convictions of both the defendant and the co-defendant.
Yes.
Of aggravated rape.
Yes, except for the fact the jury acquitted the co-defendant.
So is it an integrity of the jury? Is that the problem? They have to act consistently?
I think in this case the jury had to find that a joint venture existed, that there was
They
a
did.
mutual intent to rape.
But they did. They found that there was an intent to rape.
With respect to Mr. Medeiros, they did not find that there was a mutual intent to rape with respect to Watson. They found that Watson did not rape the complainant. And if you look at that, there's no set of facts that this jury could have relied upon in convicting Mr. Medeiros of the aggravated rape, because they found that there was no one else in the tent that also committed this rape along with him. Your Honors, I see I have 33 seconds left. I have another issue, which would be the ineffective assistance of counsel in introducing the complainant's medical records without redaction. And I would suggest to the Court that looking at the record, it is clear from the record that it was ineffective for counsel to introduce the medical records. There was a statement of the doctor indicating that her clinical impression was one of rape. That went to the liability of this case, the ultimate issue to be decided by the jury. And I would suggest that under no circumstances could counsel be deemed to have been a zealous advocate for his client and rendered effective representation in introducing those records without redaction.
Thank you, Ms. Marmor. You're the first person who's confined 30 seconds to 30 seconds. I commend you. Good morning, Ms. McKenna.
Good morning. If it please the Court, Gail McKenna, our Assistant District Attorney for the Commonwealth. What we have here today is an argument that the essentially disfavored rule of consistency should be extended to joint venture cases.
Ms. McKenna, can I just interrupt you and go straight to Justice Spina, now Justice Botsford, now Justice Marshall's question, which is, and I'm looking at Chavani, there's no doubt that one cannot commit a conspiracy alone, right? First sentence. It is
I
also
think there is some doubt about that, Your Honor. And I think that's what I was getting to here.
Well, let me just finish. So,
Sure.
You may ask us to overrule Chavani. That's no doubt one cannot commit a conspiracy alone. I'm just quoting. Also, it's true that if at a single trial for conspiracy, all but one of the defendants are acquitted of the charge, a conviction of the remaining defendant must be set aside and then going back without jurisprudence. And then the Court goes on to discuss about what happens if you get conspiracy in separate trials. If in this case, not all joint venture cases, but if in this case the Commonwealth must prove as part of the statutory element that the aggravated rape was a joint, what makes it aggravated is joint, why in the circumstances of this case would the Chavani rule not hold?
Well, this was a joint venture. It wasn't a conspiracy. And
No, I understand that, but you can't get the aggravated rape piece unless there are two people.
Well, there was no inconsistency here because, first of all, the co-venturer was found guilty of an assault and battery that could only have happened as part and parcel of this rape.
Why? Why couldn't it have been the grabbing her and pulling her into the tent?
Because the entire story was that he grabbed her, pulled her to the tent, and grabbed her arm and held her down so that the defendant could rape her.
But the
That
jury
was all
could have
part.
rejected.
Well, the judge also gave an instruction on withdrawal. So the jury could
Although the
have.
withdrawal wouldn't apply to the assault and battery. The assault and battery is, you can't withdraw from an assault and battery after you've committed an assault and battery.
Well, you can.
Grabs her, and grabs her arms, pulls her into the tent. There's an assault and battery. You may be able to withdraw from the rape, but
Right, but
I'm
the judge
already
gave
looking-
the proper instruction, I would say, on withdrawal. So the jury had an alternative reason to give a different verdict to Watson. Now, I would say...
McKenna, can I just, before you go on...
I'm sorry?
Before you go on, I'm really looking for legal help. Forget about the
Let me give
facts.
you that legal help because I think I have it for you. And that's that the rule of consistency, which is what the defendant is asking here, to extend the court from a very limited conspiracy case, is asking to say that this rule that's only applied in cases where every single co-conspirator is tried together in a case and all but one is acquitted, that's the only time this rule of consistency is applied, should be extended to joint venture cases. Well, the First Circuit doesn't apply this rule anymore.
Forget about joint venture cases. I only want to you're saying even when it's an element of the crime that there have to be two people, the reasoning underlying Chavani should not apply. And my question is, why not?
Well,
you may ask us to overrule Chavani. I don't mind if you ask us to do that.
Because the general rule is that mere inconsistency alone doesn't negate a verdict. We respect what a jury does, no matter how irrational it may seem on the surface, so long as the evidence is sufficient.
Well, let's take a conspiracy trial.
Sure.
Make it very simple. Two co-conspirators.
Right.
And let's say there's a Bruton problem, and they have to have separate trials. If the jury convicts one on a conspiracy theory but acquits the other on a conspiracy theory,
And these are separate trials.
separate trials.
We've never had a problem with that. The only time we've had a problem is when that they've been tried together. But the First Circuit...
And why is it so important that that this rule only applies at a joint trial?
Well, it
What is
doesn't
the
anymore in the
difference in a
First
joint trial?
Circuit.
Are we not to allow juries deciding co-defendant cases to act inconsistently as to the co-defendants?
Well, and it's been abrogated in cases involving joint trials of co-conspirators. In the Buckuvalas case, Bucuvalas, in the First Circuit in 1990. I mean, it's already been abrogated based on
No, well,
the
nobody's
Supreme Court case of Powell.
Ms. McKenna, nobody's abrogated us. So,
Well, I understand that, but I think
what
the
I'm
reasoning-
saying to you, my question is that you may ask us to overrule Trevani, but I can't understand not all joint ventures, but where it's an element. You may not agree with Trevani.
Well,
right?
No, what I'm saying is what we already have is a very narrow, restricted rule. And what the defendant is asking you to do is to ignore that the evidence at trial was sufficient as to him to support his conviction, admittedly so, and to expand this rule that the Supreme Court and the First Circuit and other jurisdictions have said is an antique in order to vacate a conviction that has sufficient evidence, and to tell the jury that, look, even though the evidence was sufficient and you may have had some reason to acquit the co-defendant, well, we're going to take that verdict away from you, jury. And I would suggest to the court that if we're going to have a rule like that, we need to tell juries that if you come back with an inconsistent verdict, we're going to start taking verdicts away from you.
Or we need to tell them that you have to, in order to convict one in these circumstances, you have to convict both.
Correct.
Could you explain to me your withdrawal theory here? You said the jury was properly instructed on withdrawal. That
Improperly instructed on withdrawal.
Was improperly instructed.
Correct. The judge gave an instruction on withdrawal, although it was not called for by the evidence. So.
Okay, all right. But
Right.
having given that instruction, is it your argument that the jury could well have concluded that the co-defendant who was acquitted, in fact, withdrew from the venture?
It could have sent them down the wrong road.
Okay. So that's a sensible thing that they may have concluded based on the jury's instruction.
Sure. Or they
But
simply.
if there had been a withdrawal, would you still have established the joint venture? I mean, does the joint venture get established before the withdrawal, essentially?
Absolutely. Because any act whatsoever, even standing guard outside the tent, would have been enough. I mean, what my sister suggests is that both men had to have committed the exact same crimes in order for the verdict to stand, and that's never been our law. There's also cases out there that say that, and these are more examples of inconsistent verdicts, that where one person is insane, the joint venture's who's not insane verdict does not get vacated, even though the other person couldn't form any intent whatsoever. That's McGrath and Tracy. McGrath is 358, Mass 314, 1974, and Tracy is 27 Mass Appeals Court.
But that's not an element of the offense.
Was somebody's intent?
The joint venture. Or, I mean, this says rape is
Absolutely.
committed by a joint enterprise. That's the words of the statute. So if you have, how, if this jury acquitted the other defendant, how can they find beyond a reasonable doubt that this rape was committed by a joint enterprise?
They didn't acquit him. They found him guilty of a joint venture of the assault and battery, and the assault and battery is part and parcel of this rape.
Was the assault and battery, was that a joint venture theory?
Yes, it was. And that's
Was
all
pres-
the jury was instructed on, was that the assault
Because
and
we have
battery was
no
part of
way
the
of
joint
knowing
venture.
why they acquitted the co-defendant. It
Of
could
course
be any
not.
any of a number of reasons, not
Right. Is one of
not
the jurors
necessarily
said
that there
might
was a
have
lack
liked
of
to
a joint
smile.
venture.
Well, and I think that on the facts of this case, and I know the court's read the briefs and probably the transcripts, what the Medeiros did was far more serious than what the co-defendant
but
did. I mean, who knows what a jury is thinking?
Ms.
But that's why we don't apply this rule of consistency.
Ms. McKenna, let me try and see if I can get it a different way. In your brief, you argue that a conspiracy, and you rely on it, and you rely on the 1935 case, the essence of a conspiracy is an agreement.
Right.
are you asking us to say that an agreement, as we use that term in conspiracy cases, is different from a, quote, joint enterprise?
Absolutely.
Okay.
In our case law says that, and Zanetti is the latest case that
No.
reemphasizes.
Zanetti's got nothing to do with the question I've just asked, which is it's what makes, even where it's an element of the crime, it makes a joint venture different.
Well, an agreement isn't an element of a joint venture, and we have cases like Soares, Dorenzo, Zanetti reinforces this, that,
As long as they share the intent, there doesn't have to be a specific agreement.
but it's the intent for the crime,
Right,
not
right,
each
right.
other's intent. And my sister does point out that the instruction here was that they shared the intent for the crime, and what I would say to that is the evidence here was sufficient. To the extent the defendant got an instruction like that, it raised the Commonwealth's burden, and the defendant simply got an advantage to which he was not entitled at this trial. And if there were, for some reason, a retrial in this case, he wouldn't be entitled to that advantage again. So, I mean, that's how that would wash out in the end here. But this is a case where, first of all, the verdict wasn't inconsistent, and second of all, this rule of consistency, which is just sort of this antique that's lasted in the law in Massachusetts, certainly shouldn't be extended.
So you think we should overrule Cerveni?
Well, you know what? It's not squarely in front of the court, and I don't know when the next time it would be in front of the court that we would have a case where every co-conspirator would be here, and all acquitted except for one. And I know that the court is reticent to reach issues that aren't squarely before it. That's not squarely before it. All I'm saying is that based on all of the law that's developed since, that it's not appropriate to extend that. So that would be my argument in this case. As far as the other argument having to do with whether or not counsel was ineffective, I can rest in my brief in that unless the court has any questions, but essentially it's just not developed enough on this record in order for the court to rule on this, whether or not all the choices that defense counsel made were legitimate strategic decisions that were or were not manifestly unreasonable. So,
Yeah, going back to that, I
Sure.
gather that in the cross-examination of the alleged victim, the defense counsel wanted to impeach her with the medical reports, saying, "Didn't you say that?"
yes.
And the judge would not allow the
No.
prosecutor? I mean, did
What
the defense counsel
happened
do
here
that?
was, and it takes a careful reading of the record, but what happened here is that defense counsel went to impeach her with the medical records, and the judge asked, "What are you impeaching her with?" And he said, "The medical records." He never told the judge that it was the victim's statement in the medical records, but he gained a tremendous advantage from that because he never asked her about the statements in the record, so he never gave her a chance to explain them. He simply put all her statements in.
But he also tried to refresh her recollection with the medical records, and the judge wouldn't allow that either.
Because he didn't say that they were her statements.
What difference does it make? You can refresh somebody's recollection, as Professor Irving Young used to say, with a banana.
Well, and I have heard that as well. But I think the advantage to him in the end and what he was really pleased with was putting in all of these records without giving her an opportunity to explain them. And, you know, he was the one standing there watching her testify. He was the one evaluating the strength of her testimony. And he put it in the records without redacting them because of the strength of the differences in the record that he thought were of benefit to him. To the extent that the argument is that he should have done less impeachment, I just don't think that holds water because he did so much impeachment and yet was unsuccessful in shaking the credibility of the victim. So I think he did a lot with what he had, and it simply was unsuccessful here rather than a poor strategy. So unless there's any other questions, thank you all for your
Thank
kind
you, Ms.
attention,
McKenna.
and I would ask that the convictions be affirmed. Thank you.
Two cases. Single round.
SJC-10442,